Good afternoon. I apologize. I was waiting in what I thought was a waiting room.
You're here. We're glad to have you. Is your counsel coming, Mr. Driscoll?
I think
Here, I just don't see my picture.
We don't either, or I don't either.
Hold on a second. Let me see why I'm not getting video. Here we go. I don't know why it's not coming up. I can see everyone else.
It would really be nice if we could see you.
There we go.
Nope.
No?
There we are.
There we go. All right. Sorry about that.
Okay, is there any reason we can't get started and go on the record?
Mine says Elizabeth Seltzer, but that's not correct.
Okay. Well, Mr. Driscoll, you're Mr. Driscoll, right?
That's correct. Let me just see if I can correct this.
Sure.
I can correct that for you.
Oh, okay. That'd be great.
Carly is a very powerful woman. Okay, so let's go on the record. We are, of course, the Board on Professional Responsibility. It is July 8th, and we are here in the matter of In re Archie Rich. This is board docket number 18-BD-42 and disciplinary docket numbers 2013-D003 and 2013-D181. Starting with disciplinary counsel, can the parties and counsel, can counsel identify yourselves for the record?
Thank you, Mr. Chair. On behalf of the Office of Disciplinary Counsel, my name is Miles Link.
Thank you. Mr. Driscoll?
Yes, sir. Good afternoon, Mr. Chair. My name is Richard Driscoll. I am here on behalf of the respondent, Archie L. Rich.
Thank you. Good to have you here. Good to see you, Mr. Rich. Okay, so first thing, a couple of housekeeping issues before we get started. As you know, we're conducting this hearing on Zoom. Zoom can be challenging for two people who are talking at the same time. So Mr. Driscoll, Mr. Link, I would ask if you can pay attention to the board members who it looks like we're trying to get in with a question. Please let us do that. We'll raise our hands to try to get your attention. And to the extent that that's not effective, I'll try to play traffic cop and interrupt to have people slow down if someone's got a question. If you are not speaking, please mute yourself. So at this point, really, everyone should be muted except for whoever's going to be arguing first. Excellent, thanks. And of course, board members will unmute if they've got a question as things move along. Any questions about any of that? Great. I assume disciplinary counsel is arguing first. Have you guys talked about that? Is that correct?
We've not talked about it, but I think that would be the normal procedure since we're taking the exception.
Yep.
That's what I had assumed.
Great. Mr. Link, would you like time for rebuttal?
Yes, thank you.
How much?
5 minutes.
Sure. Sounds great. All right. As soon as Mr. Turner he's got the clock set up, Mr. Link, whenever you're ready.
Thank you. Mr. Chairman, members of the board, disciplinary counsel takes an exception to the sanction recommendation of the hearing committee because the hearing committee felt that Kersey mitigation should apply, and therefore the disbarment mandated by In re Adams for this type of misconduct, misappropriation should not be applied in this case. We disagree with that. And I'd like to start, if I may, by reading just 4 sentences from the hearing committee's report, which I think puts into perspective what the issue is for this board to decide. These 4 sentences are taken from page 62 of the hearing committee's report. 1, each and every time respondent and/or his firm acted to defraud a medical provider, that act was premised upon a lie to that provider for the benefit of respondent's firm. Deliberate misconduct. 2, each use involved a knowing and intelligent determination to permanently deprive the medical service provider of payment to which the medical provider was entitled and which respondent had promised to pay. 3, such conduct exhibits a mens rea and an ethic which we do not believe can be attributed to respondent's disability. But, and here's the 4th sentence, however, each and every act to defraud medical providers occurred when respondent was in the throes of his disability. And the challenge for the board is, what does that last sentence mean?
Well, isn't your, like, what do you do with Kersey, right? I mean, Kersey was a case where there was intentional misconduct, and they've got that footnote where everybody seems really worried about the intentional misconduct. And yet, Kersey said, because alcoholism or alcohol use disorder is such a serious and prevalent and understandable disease, that nonetheless, Kersey mitigation is appropriate. I mean, they didn't call it Kersey mitigation because it was Kersey.
But the court never said, either in Kersey or in any of its progeny, that simply to show alcoholism is enough to show that the alcoholism was the proximate cause or a substantial cause of the misconduct. In fact, one of the 3 elements to a respondent must prove in order to be eligible for Kersey mitigation is that by a preponderance of the evidence, the disability was a substantial cause of the misconduct. And we argue that's not the case here. Respondent argues that since we agree that the 3rd count in our specification of charges that related to his failure to meet the statute of limitations for the Mr. Turner was caused by his AUD, his alcoholism, therefore all of his misconduct was caused by his alcoholism. Not even the hearing committee agreed with that. I refer you to finding of fact, if I may, I refer you to finding of fact 56, where the hearing committee said his AUD does not explain his failure to provide a forthright accounting, the delay in response, or the incomplete compliance. So it is clear, just because a respondent has, in this case, alcoholism, in another case, another disability, that fact alone has never been sufficient. And in the recent case of In re Schumann, the court made that clear. That fact is not sufficient to show the disability. I'm sorry.
It's okay. I'm going to interrupt you because I'm going to take you back actually to where you started. You read those sentences to us, and I don't know what that gets you, or given the ultimate finding of the hearing committee, which is that Kersey did apply.
That's, Ms. Pittman, that is the issue. This board owes no deference to a hearing committee's ultimate findings of fact, and what we are asking the hearing committee to do is to look at the record of this case and make that finding for itself.
Okay.
The hearing committee.
I'm going to interrupt you again and go back to those sentences, because those sentences are contained in a conclusion about whether or not there was fraud related to the letters that were sent to the medical providers, as I understand it. Did ODC charge Mr. Rich with fraud?
We charged him with a 5.3 failure to supervise the paralegal and who sent the letters, because he knew, well, I mean, in fact, all the failure to provide accurate information to the medical providers facilitated his scheme to misappropriate only the medical provider funds, not the funds that were due and owing his clients, because they would know if they weren't getting what they thought the settlement should provide, but to misappropriate the funds that were due and owing to the medical providers. So this was part of the scheme, which was the violation, which also charged under 1.15A. And it was all part of a systemic process by the respondent.
Mr. Link, but what I struggle with is this finding of fraud, which Mr. Rich takes exception to, and we'll address it with him as well, I'm sure. But what do we do with that when there's no charge of fraud?
Well, the hearing committee said there were acts to defraud the medical providers. Now, the disciplinary council doesn't want to get hung up on sort of a semantic argument about whether his 1.15A misappropriation, did he in fact defraud the medical providers? as a matter of fact, that probably is what happened. But for the ethical violation, for the rule violation, it's 1.15A, it's misappropriation. The money should have gone to the medical providers. It did not. And
I don't see in this section, these sentences that you read, the connection to the misappropriation. This is, again, in relations to count 2.
No, because count 2 charges conduct that was intended to facilitate the misappropriation. The 5.3 failure to supervise the paralegal didn't happen in the abstract. It didn't happen in the ether. It happened as part of his scheme to take money that was due. And so that's why the hearing committee put, if I may, I don't mean to, but if I may, that's why what the hearing committee was doing here was summarizing their findings, and this is where they put them. That's where we find them. That's where I read them from. But the 2 schemes, count 1 and count 2, have got to be read together. Count 3 is different. It's separate. That's not an issue here. I would also point out on this point, Ms. Pittman, the respondent's brief, almost this whole second half of the brief from page 18 to 31 is almost devoted to rehabilitation and how that is an irrelevant issue in this case, since the issue is whether or not the disability caused the misconduct. But even if you were to focus on rehabilitation, the evidence introduced at the hearing shows that the rehabilitation is not complete because all of the medical providers have not been repaid. And I refer you to Respondent's Exhibit 14, where he notes that in fact he has not repaid all of the medical providers. And then if you look at the specific findings of fact by the hearing committee, they say there is no record that has been done. So I only make that point to say, if the board is concerned about whether he's been rehabilitated, he has not made out a complete showing of rehabilitation.
Mr. Link, though,
but that's irrelevant. The fact is his AUD didn't cause the misappropriation.
Mr. Link, can I take you back to your site to paragraph 56? Because I'm troubled by what you said in light of the language of that finding of fact. You read his AUD does not explain the failure to provide a forthright accounting, delay in response, or the incomplete compliance. Sort of as support for the proposition that the hearing committee didn't find that the AUD, that the alcoholism caused the rule violations. But the very first clause of finding of fact 56 is that we find respondents proved the original violations were caused by the AUD. I don't understand how your use of that is anything but really disingenuous.
Thank you.
It doesn't stand for the proposition you're saying. It stands for negation.
With respect, I disagree. What the distinction you points out, and what the 4th sentence that I read when I started also points out, is this dichotomy that the hearing committee found, and they just didn't resolve. Our position is they essentially threw up their hands and said, we have evidence that alcoholism was present, and based on that, we're going to find that it caused these violations. But if you actually read what they wrote, you read the first sentence, I started with the second, if I may, we quoted that in our brief, that there's this dichotomy, and that's why these ultimate findings of fact, which determine what the sanction should be made by the board.
Okay, Margaret, you were going to say something, sorry.
I'm sorry, there's someone else going ahead.
Yeah, Mr. Link, are you suggesting that when somebody has AUD, the fact that they can't meet a financial obligation of some sort is evidence that they're not rehabilitated when they're no longer engaging in abusive use of alcohol?
One of the elements of rehabilitation when a party is attempting to show cursory rehabilitation is that they have remedied whatever harm they've caused. And if they have not, in fact, remedied all of the harm they have caused, then in fact, it's hard for them to say that they are completely rehabilitated. They may no longer be abusing the drug or the alcohol, but the misconduct did in fact take place, and they need to show that in fact they have remedied that abuse.
So then your position is that Kersey is not available to Mr. Rich for two reasons. A, he's not rehabilitated, and B, his actions were not the result of his AUD.
Well, with respect, our position is the second of the 2 points you made. We believe rehabilitation, because his AUD was not the cause of the misconduct charged in count 1 and count 2, we believe the argument with respect to rehabilitation is irrelevant. In fact, if I may, it's a shell game. What the respondent wants you to do is focus on the rehabilitation issue and let us discuss it so that you don't focus on the causation issue.
So why don't we
we've said in our,
we're going to focus on causation then. Okay, so all experts, I've read the testimony, all the experts indicated that a person with AUD will make bad decisions or have poor judgment. Okay. And examples were provided, you know, deciding to drive while drunk, spending money that you don't have, cheating on your spouse. All of those are intentional acts. Okay. Your brief refers to those as sins of commission. And state that they're not entitled, at least on this record, to Kersey mitigation despite that testimony. And instead, only the sins of omission, I think is what your brief calls them, that would be the negligence in count 3 that would be entitled to Kersey mitigation. So I'm wondering, what is your legal authority for that statement first? And second, how do you reach that conclusion that there's these factual findings when Dr. Smith testified specifically that the misconduct was caused by AUD?
well, with respect, the doctor may have testified. I would argue that's not within his medical purview. Stealing from medical providers was caused by the AUD. It was certainly within his medical purview that the respondent suffered from AUD, and he could talk about what are the general effects that AUD has on people who suffer from it.
Correct.
It's up to the hearing committee.
Let's go to question 1. What's your best authority that Kersey mitigation does not apply, as your brief says, to sins of commission?
Well, I would look to the In re Schumann case where the court said there the respondent was saying that his depression caused the misconduct, and the court looked very carefully at what exactly had happened and said that no, that was not the cause of your misconduct. And again, we're not saying as a general rule, and I think we said this in our brief as well, that intentional misconduct can never be a cause or can never entitle someone to Kersey mitigation. That's not our point. Our point is looking at the record of this case, looking at the multiple actions respondent took for the purpose of ensuring that his law firm would be solvent, we would argue indicates that the AUD was not the substantial cause of his misconduct.
I want to talk to you about Schumann then, okay? Because you point to Schumann as being something in support of, and I appreciate that you're not saying all intentional acts, but you do point to Schumann and that you think that Schumann supports this concept of the intentionality undermining Kersey. But here, I read Schumann a little bit differently. I read Schumann as saying that we've got evidence of depression, evidence that Mr. Schumann is doing significantly better while the actual misappropriation is taking place, and absolutely no evidence that anything other than the misappropriation, you know, was sort of, there was something problematic going on in his life. So can you talk about how that applies here, where here you have evidence of other aspects of Mr. Rich's life being affected by AUD? We do not have evidence that he was doing significantly better while the misappropriation was taking place. And so those are pretty significant differences, I would say.
And I would point the board to a few findings of fact that I think respond to that and rebut that. First of all, finding of fact 96, his binges did not get progressively worse over time. Finding of fact 98, he was able to avoid binges when circumstances warranted. And I think making his judgment calls about which accounts to misappropriate or circumstances that warranted. And finding of fact 82, he misappropriated in order to maintain a positive balance in his firm's operating account. When you look at most of the cases where Kersey mitigation is available to a respondent, there is in fact a general failure of the respondent to manage their affairs and to conduct affairs at all. We don't have that here. We have a conscious decision.
I'm going to challenge you a little bit on that, because we do have that he doesn't come to the office, but for maybe 9 days a month. We do have that he's binge drinking. Perhaps it's not getting progressively worse, but it seemed pretty severe. I think that's what the hearing committee called it, was severe binge or severe. We have the testimony about, abandoning his mom at an airport and the relationships that were falling apart in his life. So are you really saying that there's no evidence that other aspects of his life was affected by AUD?
Thank you. Great. What I'm saying is we don't have a preponderance of the evidence, which is what he needs to show that in fact this AUD caused him to undertake the steps he methodically, consciously, carefully, rationally undertook in order to misappropriate funds from the medical providers. But Board Member Pittman, this is exactly what we're asking the board to do. And while you and I may disagree, this is exactly the kind of ultimate fact and conclusion that the board has to make on this record. And I refer you to the record. I refer you to, and you've obviously read the report and the testimony. We believe on this record and following Temple that you've got to look at each case on its merits. This and really what, if I may, what this is about is, do we apply Adams? That's what this case is about. And the reason why respondent wants you to focus on something other than was the AUD the cause is because he doesn't want Adams to apply. We all understand that. If the court wants to make a separate or special or new exception that will extend and expand the application of Kersey to situations like this,
Mr. Link,
I say
Mr.
let
Link,
the
I
court
want to
do it.
interrupt you here. Because I'm getting confused. I thought you had, I had a question for a while now, and I thought you were going to answer it, but now I'm getting confused because it feels like you're making a different argument. Is disciplinary counsel saying to this board that the hearing committee's findings are not supported by the record, that there's a lack of sufficient evidence for the findings with regard to Kersey mitigation? Is that what you're arguing, or are you arguing for a determination that there's been a misapplication of the governing law? Because it seems to me you're arguing that it's an insufficient record for the finding.
That Board Member Sargent, that's a great question, and frankly, I would argue that we're arguing both. We think that the hearing committee did not want to apply the Adams requirement of disbarment in this case, and so they sought to avoid it. Perfectly understandable.
What's your support for that?
But we also
record? What's your support in the record for accusing the hearing committee of wanting to circumvent Adams and therefore?
Because as I hoped I've shown in my references to the hearing committee report, the hearing committee was, and its findings of fact and its statements, the respondent's conduct exhibits a mens rea and an ethic which we do not believe can be attributed to respondent's disability. That was the hearing, and yet it nonetheless did attribute it to the respondent's disability. You can't have it both ways. That's what we're saying. And the hearing committee sought to have it both ways. Totally understandable. It's human. But we're asking the board, you've got to look at the records, look at the findings, and it's the ultimate findings. This evidence entitles the respondent to a Kersey mitigation. We think that was wrong. We think the board owes no deference to the hearing committee on that, and we urge the board to, do what it has to look at the record and make the proper finding. We think the hearing committee punted, And
Okay.
we ask the board not to do so.
Great. You'll have more time on rebuttal. Mr. Driscoll, you have got 20 minutes as soon as Mr. Turner gets the clock set up, and he does. Mr. Driscoll.
Yes, sir. Members of the board, we sincerely appreciate your time today. We know that you're all volunteers, and we appreciate the time that you devote to make the bar a better place. I'd like to start out just by making the clear statement that the respondent does not contend that his conduct was excusable. He admitted unequivocally to the conduct as charged in the specification. Instead, what the respondent has argued below and what the hearing committee accepted was that the circumstances of his AUD were such that they substantially affected both his professional life and his personal life, such that the misconduct charge was substantially affected by the AUD.
Mr. Driscoll, I'm going to interrupt you there because it is an interesting question, the causation, right? So
Sure.
it does seem as though he's selected between clients and medical providers. He paid the individuals who are most likely to file a complaint because they're the ones who know about the settlement. And that does kind of look like a selection of sorts, as ODC is arguing.
Can I respond to that, ma'am?
Oh, please do.
Okay, so this is a failure to apprehend the normal process that transpires when a personal injury matter is settled. Normally, in a personal injury matter, when the money comes in from the insurance company or the defendant, the funds are deposited into the trust account and the attorney waits for the check to negotiate. When the funds hit the account, the client is notified. The client comes in, as Mr. Rich testified, you meet with the client, you go over the settlement statement, the client signs the statement, and the client walks out the door with a check. So those funds are gone immediately. Next come the funds for the law firm. Those funds come out so that when all that transaction has happened on the day of settlement, the only thing left in the account are the healthcare provider funds.
So can you point me to the record? Because and it might be that I just missed it, but my memory of the testimony was that Mr. Rich's current associate testified to current practice, which what you've just described seems consistent with that. I don't know if I recall there being a similar set of testimony.
The only statement in the record by Mr. Rich was he pointed out that the client wants their funds immediately on the settlement date. And I do have a citation for it.
Okay.
If I can quickly find it.
If you can't, I can search for that.
Let me see here.
I don't want to take up your time on that.
I want to answer your questions.
I'm going to skip ahead.
Okay, it's page 384 of the transcript.
Okay, thank you.
Mr. Rich is describing the settlement process and states that the client wants their money immediately. So that's the normal customary process that a settlement goes through in a personal injury case. The lawyer doesn't hold the client funds in the trust account because the client wants their money right away. And that's what they hire the lawyer to do. So that's the reason why the medical provider funds are the targeted funds for a misappropriation. It's not because there's some conscious decision, and of course there is no testimony that there was such a contemplative determination to take those funds. If you look at the appendix to the
I don't want to interrupt. If you've if it's important to your point, Mr. Driscoll, please go ahead. I've got a question for you then.
20 seconds to finish this point. The point is that if you look at the last 2 pages of the hearing committee report, if you look at appendix 2, which is a listing of the daily balances on particular test dates, you can see that the balances are sometimes positive and sometimes negative. They're rarely in sync. And so There are many days when the balance is deficient, meaning there's less funds in the account than there needs to be. But there are also at least 12 days when the funds in the account are substantially greater than the amount of money that needs to be in there, which demonstrates that it's not some calculated plan to always steal from the healthcare provider. It's really a lack of attention in managing the trust account, which is consistent with both the expert testimony and the finding of fact regarding his failure to manage the office, absences from the office. Even when he's in the office, the effects of the AUD continue. He's hazy, he has a lack of focus, he has an inability to complete tasks. All of this is consistent with the AUD, and you add to that Mr. Rich's diagnosed ADD and his inability to deal with math as he's testified, and handling of the accounting is not his forte to begin with a clear mind.
So, Mr. Driscoll, I want to ask you about In re Schumann and ODC's, I won't say reliance on that opinion, but citation of that opinion for, I think, the proposition that because a respondent is able to distinguish, in that case, between former clients and current clients, and in this case, between clients and providers, that shows, that kind of undermines the applicability of Kersey mitigation. I'm assuming you've had a chance to read Schumann and to think about ODC's application and use of that opinion. Do you find that ODC has correctly cited and used that opinion, or do you take issue with it at all?
Well, Your Honor, the respondent takes issue with that. And in fact, I think that the citation to Schumann is an error, because the Schumann case doesn't stand for the proposition of intentional versus unintentional conduct. In the Schumann case, you had an attorney who misappropriated more than $230,000 of refunded filing fees and then refused to acknowledge his conduct. And then, in addition to refusing to acknowledge his conduct, attempted to assert a Kersey mitigation based on a severe depression. But the contemporaneous notes of his treating physician showed that in, I guess, January of 2013, when the refunds began to come in, that Mr. Schumann had actually improved and had changed his medicine and was no longer experiencing the symptoms of his severe depression, such that when it got to the point that both the hearing committee and the board and the Court of Appeals made their determination on Kersey, the decision wasn't based on whether his conduct was intentional or not. It was on his failure to meet even the first prong of Kersey, that he had failed to demonstrate that he was suffering from a disability at the time of the misconduct. And in fact, the Court of Appeals pointed out that the depression was under control so that it was not disabling under Kersey's prong. And as a result of that, there's no way he could meet the second prong, which is causation. And that's what Schumann stands for. There are substantial distinguishing factors between that and the circumstances before the board today. Here, Mr. Rich admitted his responsibility for misconduct. He owned his conduct, and he pointed out that it was due to his AUD. All the experts and all the fact testimony agree that AUD was severe from 2010 to 2014. Yes, ma'am.
Mr. Driscoll, let me ask you a little bit about the expert testimony and whether it was specific enough.
Okay.
So you have Dr. Smith and Dr. Telfson, I believe, both testifying about the poor judgments the individuals with AUD have, the bad decisions that they make. Sometimes it comes with depression and the absentee from office and things of that nature. But Dr. Smith, his testimony about like the connection to the misconduct kind of refers to the misconduct as fiscal responsibilities, and doesn't really get more to the specific question that I think ODC is raising, which is this ability to distinguish between clients and medical providers. Do you think that the testimony was specific enough? And if so, can you describe why you think it's specific enough to establish the causal connection?
Well, we do think that the testimony, and in particular, the testimony of Dr. Smith and Dr. Tellefson establish that the AUD is severe enough to cause the misconduct. There's a specific passage I want to find that Dr. Smith makes that is particularly important here. And in his testimony, he points out, just bear with me here a second. Dr. Smith refers to, I'm having a little bit of difficulty putting my finger on it right now, but Dr. Smith refers to the fact that this impaired judgment of the alcoholic is such that they will make these decisions that are not, as in the words of the Temple Court, purely voluntary or purely involuntary, but these decisions that are clouded by an impaired judgment such that, okay, I'll move this money now, I'll take this money now, and I'll be able to pay it back and fix it later. That was the testimony of Dr. Smith, which is directly consistent with the testimony of the respondent, who talked about how when he was in the office, he felt like he was managing a dike with a million holes, and his goal was just plug the biggest leak at that time, knowing that at a later point in time, he would have the ability to really fix it. And that's the thinking, the impaired judgment of an individual who's functioning under the cloud of an alcohol use disability.
What really has to be shown to show that the alcohol use disability was a substantial cause of the misconduct? I mean, if the person is able to reason and think clearly, but is nonetheless exercising bad judgment, your position is that counts, because the bad judgment is let's assume that the AUD is a but-for cause of the bad judgment. But at some point that feels a little attenuated, doesn't it?
Well, it's not that he's functioning clearly. There is no testimony on the record that Mr. Rich is functioning clearly and deliberately in all of these conducts. You see a pattern in the appendix of funds being moved from the, for example, under count 1, you see this pattern of funds moving from the 2811 IOLTA account into the operating account. And you also see these circumstances where the funds fall below. But if you try and correlate the amounts, it's never a specific amount that correlates to any one client. There's no intentional movement of an amount of money that correlates directly to one medical provider or one client. It's always a more general conduct. So you have that aspect. With regard to count 2, which I would just point out, is not an intentional act. It's a failure to supervise. It's a neglect, which makes it more of the nature of count 3, the failure to timely file an action before the limitations run. Under count 2, you have a circumstance where someone is not in the office, is delegating everything to support staff, so much so that his key person, Ms. Mendizabal, actually quits in March of 2011, and in response, and in her testimony states, she's not quitting because of the money, she's quitting because Mr. Rich is never in the office. That's her point. And so you see this these things are going on in the office when he's there and when he's not there. It's an effort as the attorney appears in the office, recovering from the after effects of a hangover or just the general effect of the AUD, which it sort of, I won't say entices, but convinces the attorney through this impaired judgment that the decisions that he's making are appropriate for the time. But those decisions, when viewed through the prism of clarity and a sound mind, make no sense at all. I mean,
yeah, I guess I'm wondering how broad that can get, right? I mean, if the person deliberately chooses and undertakes a course of action that's a violation of the rules in order to get out of the office earlier and get to a bar sooner because the person is suffering from alcohol use, which is a horrible disease, right? And everybody agrees with that. Is that enough to meet the second prong of Kersey? If it's not as a result of impaired judgment, it's just an eager desire to, the person is otherwise thinking clearly and acting intentionally, and is, sort of doing good reasoning, other than their underlying desire to get out of the office quickly and get to a bar. They cut corners, don't return client calls, do whatever it is that's a rules violation. Is that enough? Does that get you to but for a substantial cause of the misconduct?
I would argue it does, and here's the reason why. The nefarious nature of AUD is that it convinces the person suffering from the malady that it's more important to get the next drink, it's more important to binge than it is to take care of the responsibilities that are confronting them in their normal daily life.
What if the person intentionally takes client funds, knowing that they're taking client funds so that he or she can buy alcohol or can go out?
That's directly related to AUD.
Then
that has been pointed out as an indicator of a causal nexus in case law.
I guess what I'm wondering is that if it is that broad, then for purposes of someone who is suffering from AUD, if they're really in the throes of it, is there meaningfully a second prong of Kersey?
Yes.
When would there be a situation if the person is actively suffering from AUD and the second prong of Kersey is not met? And there's misconduct and the second prong of Kersey is not met.
Could you state that again, sir?
Yeah, sure. I'm wondering if it is that broad, when would there be a place where someone is actively suffering from AUD? They're in a period where there's a lot of binge drinking. They're in a period where they're actively acting as what we used to call an alcoholic. And there's misconduct of any kind. When would there be a time when that doesn't meet the second prong of Kersey?
It would depend on the severity of the AUD at the time. When you
assume it's severe, assume it's really severe. Does really severe AUD mean in every case a fortiori second prong of Kersey is met?
I understand your question. The question is, does the existence of AUD alone establish causation? And it doesn't. What the case law said is that you must look at and see whether the AUD is having an effect or an impact, a substantial impact on not only that one particular activity, but other areas of the respondent's life. And here,
if the person is stealing money to go to the bar, that's caused by AUD. If the person is stealing money to, I don't know, buy a boat, that wouldn't be. Is that?
I mean, it's an interesting hypothetical.
I'm just trying to figure out, because it does look like this way of parsing it goes really, really broad. And that feels really, really broad, kind of just generally feels wrong in the law. And I'm wondering if there's a limiting principle.
Well, I think that if the conduct does not appear to be caused by the AUD, in other words, there are many people that are functioning alcoholics who have absolutely no impact in their life. They have an uncommon or uncanny ability to drink and post the next morning and be right on top of their game. That would be the type of individual who may not be able to demonstrate it. But when you have an individual like Mr. Rich, whose personal life is falling apart, he's losing contact with his relatives, he's losing contact with his family, he's losing contact with his friends, his marriage fails, he's so devoted to his alcohol that he ends up not once but twice abandoning his mother at a time when he should be attending to her needs. He's in a professional life, he's not showing up for appointments. He's not just not coming into work, he's not meeting obligations and appointments. His own employees are so upset about the manner in which he's acting, they quit, or in another case, they leave and take a major case with them. There are a lot of circumstances ongoing in Mr. Rich's life that demonstrate that, as Dr. Tellefson said, his life circles the bottle. He's just.
Mr. Driscoll,
I think
I'm going to.
a question. In the Schuman case, Schuman's expert testified as to the disability in existence at the time, but the court found that the expert could only speculate as to causation. How is Mr. Rich's expert testimony different than what the court found insufficient to establish causation in Schuman?
If I remember correctly, the expert in the Schuman case relied on expert testimony, the anecdote from another person's testimony, not on an interview with the respondent himself. Here, Mr. Rich was interviewed by each of the experts, and his medical records from the Coleman Clinic were examined by those experts. I think he made himself available. In addition to that, you had 9 fact witnesses and 3 experts who all agreed, at least with regard to Dr. Cooter, at least to the general nature of the AUD, and with regard to Dr. Smith and Dr. Tellefson, they agreed with the specifics of, Mr. Rich's condition and its impact on his life, both personal and professional. I think there's a large distinction between Schuman and this case.
So can I ask a couple of what I think are going to be cleanup questions, but we'll see.
Sure.
I'm going to start with, is the audit complete? There's, you know what I'm referring to.
Asking, because I did want to bring this to the attention of the board. There are 2 types of issues here. One is the lien payments that were the subject of the misappropriation in 2012. The second element of provider payments is the hypothetical misappropriation as a result of the failure to supervise that would arise from inquiring of the healthcare provider, I suppose, what would you do if you knew that the settlement amount was X? With regard to the first category, for all intents and purposes, those are concluded. There are 3 to 5 healthcare providers to whom a payment is still owed, but after really an exhaustive effort on the part of Mr. Rich and his former counsel, for whatever reason, those individuals, those entities, those healthcare providers no longer exist, or in the case of one provider, Providence Hospital, they have absolutely no record of the invoice or the bill that is the subject of the lien. And so there's a disconnect there. And so we're talking about an amount of approximately $3,000. To secure that, Mr. Rich has in the 2811 account a balance of approximately $7,000 sitting that he's prepared to either pay over to the Client Security Trust Fund, or if the board has some other instruction or order, he will comply with that. That's for category 1. For category 2, the hypotheticals, it's difficult to discern an appropriate process for curing that conduct. And what we really are here today to ask is for further direction and guidance from the board as to how you would like us to go about doing that? Do we prepare a letter that we send to these providers and say, if you had known X, then what? And just if you could give us some guidance on how to do it. Mr. Rich is prepared to go forward with whatever the board decides is an appropriate approach. On that issue, I would just also point out that with the exception of the Johnson case, which was the really one in large magnitude between 12,000 and 75,500 for the settlement. Other than that case, all of the other cases have a settlement value under $20,000. So we're not talking about a large amount of money, and Mr. Rich is more than willing and prepared to move forward with that, with the understanding that some of those people will be owed nothing, because as a matter of practice, when you approach a lien holder, you always ask for a discount based on the attorney fees, because the victim should not be paying the attorney fees for the healthcare provider.
So
Go ahead. I know you had some other questions, Ms.
I have one more question.
Remind everybody we're well past out of time.
Yeah. So if we can make this as quick as possible, one thing that you know in your brief is that the objection to the conclusion on pages, I believe, 62 and 63 of the hearing committee report on the fraud.
Right.
Does it matter?
I don't think it does, because when you look at, and I'm going to take you to the page, when you look at page 61, if you begin on 61, it says what troubles us with regard to count 2 is that based on the admitted evidence, as opposed to the stipulation of responsibility, the activity respondent failed to adequately supervise. Conduct to which respondent has admitted is of a significant different character than that charged in counts 1 and 3. I think the board is troubled with what happened, as Mr. Rich was troubled with what happened. You will recall that he testified when he learned of it, when the healthcare provider approached him, it was like being punched in the gut, because he understood at that point that these letters had been going out.
Right. And so because of time, I'm going to interrupt you because we're familiar with that. I guess I just wanted sort of a bottom line. If the hearing committee has that finding in there, but given sort of the conclusion on Kersey, does the fact that they said that there was fraud based upon his testimony, specifically 400 to 413 of the transcript, does it really matter?
Well, that's an interesting question. It matters to Mr. Rich because he, as you know, maintains that he never participated in that. There was no evidence that he participated in that. And
but it has no impact on the findings. It has no impact on the actual violations findings.
It does not. But what lawyer wants to have the word fraud associated with
Understood. Understood.
All right. Thank you very much, Mr. Driscoll.
Can I just make one point before we close?
30 seconds.
Thank you. I'd just like to point out that Mr. Rich, rather than being, punished for the sake of punish, as the disciplinary council would like, really should be put up on a pedestal, in my opinion, as an example of what can happen when a AUD is actually confronted and treated and handled in an appropriate way, such that an individual is capable of now realizing truly their maximum potential. When you look at the fact that Mr. Rich attended more.
I think that's probably 30 seconds. I do hate to.
That's fine. I think that should not be lost on the board.
Thank you very much. Mr. Link, you've got 5 minutes left, I believe.
Yes, thank you. Just a few points. I'd like to take issue.
Mr. Link, I know you have a lot of important points to make, but I want to make sure that one of them is, and others may have asked this, I'd like to hear it again. If you'll address this point, on the one hand, you say it's not the expert's role to make the conclusion that the disability caused the misconduct And on the other hand, you say that the record before us is not sufficient to establish causation. What exactly are you looking for in terms of language, findings, expert? Can you tell us what's missing and what ought to be there that isn't? I think you've addressed this, but I'd like to hear it again among the points you're going to make.
Mr. Walker, as you probably know, in a civil trial, when expert testimony is admitted, experts are not allowed to testify as to the ultimate issue in the case, and that's what these experts were allowed to testify. So that was the point of my comment. It's up to the hearing committee, based on the expert testimony, that there was AUD, that AUD generally causes a general disruption in a victim's life, etc., whether or not that AUD was, as a matter of law, was the substantial cause of the misconduct here. If I may, following up on that, I want to take issue with my learned counsel's comment that this is about punishment. That's not what discipline is about, and that's not what this office is about. We totally understand the fact that people suffering from disabilities are in fact suffering, but the whole purpose of In re Adams was to set a standard for the bar and to set a standard for the public that we take this seriously. That's why it's so important to determine whether, when a respondent claims that they're eligible for Kersey mitigation, it is so important for the board to make its own determination whether or not that's the case. All that we're saying is, in this case, we totally appreciate and understand the disruption this AUD has caused to this respondent, but that's not the issue here. The issue is whether, if his misconduct was not substantially caused by his AUD, then In re Adams must apply, and disbarment is the only appropriate sanction. If the Court of Appeals wants to create an exception to that, let the Court of Appeals do that. I also want to take two.
Didn't they create an exception in Adams when they said Kersey mitigation was a way to get around the presumptive sanction of disbarment?
I'm sorry?
Didn't they make that exception in Adams when they said Kersey mitigation was an exception to the presumptive sanction of disbarment? I mean, it seems like the exception's already there.
No. But only if you meet the three elements of Kersey. You're suffering from a disability, the disability caused the misconduct, and you've been substantially rehabilitated. So what we're saying here is, what respondent is saying is that he suffered from a disability, and the essence of his argument, as you heard, is essentially because we suffered from a disability, the disability caused our misconduct. And he points to other aspects of his life to say, since they were disrupted, that somehow should convince the board that he was unable to properly supervise his paralegal, who acted through her misconduct in a way that benefited him and his firm, and he was unable to take the steps to ensure that medical providers—
Mr. Link, do you agree that the respondent showed impaired judgment in his practice of law and in his fiscal and financial activities in this case? Do you admit that there was impaired judgment here? Or do you see that there was impaired judgment here?
Well, clearly with respect to count three, with respect
how about
to the
1 and 2?
statute of limitations. Well, but Mr. Walker, if I may, whenever a respondent misappropriates funds, you can argue that's impaired judgment. When respondents misappropriate funds, fail to abide by their ethical obligations, that's impaired judgment.
And is impaired judgment something that is caused by AUD?
It may be, or it may not be. Not every respondent can attribute.
So what are you looking for here that's not here that would tell us his impaired judgment in this case was caused by his AUD in this case?
Or was not caused by, and for example.
And so what's missing?
Let me give you an example.
Mr. Link, let me interrupt you. Maybe let me give you an example. Are you saying that Mr. Rich didn't take enough of his client funds? Like he needed to drain these accounts in order for ODC to agree that his AUD caused his actions? does that get us to enough impaired judgment that's caused by the abusive use of alcohol? Is that an example that would work?
Ms. Cassidy, that's a great hypothetical, and I'm not sure I'm prepared to go that far, but let me take that hypothetical for a minute, because Respondents' Counsel said that there was no way he could have taken client funds because client funds were paid out quickly. But in fact, the hearing committee found that in at least 2 cases in October of 2012, he did take client funds. We argue that that was inadvertent, and we argue that it was because as soon as he was aware that he took those client funds, he immediately took steps to refund that money to the client. That is not the action of someone who's suffering from AUD. That's the act of someone who wants to disguise the misconduct that they're taking with respect to the medical providers.
But doesn't often somebody suffering from AUD hide their alcohol, refill the vodka bottles with water, and do all sorts of other things of that nature?
Ms. Cassidy, I'm not prepared to opine generally on what people suffering from AUD do. I make no claims to be an expert in that. What I am suggesting is that on the record in this case, it is clear respondent, yes, his judgment was impaired to Mr. Walker, but respondents who commit this type of misconduct, it is almost a definition of impaired judgment when you violate your ethical rules so blatantly, and particularly since in this jurisdiction to do so with respect to misappropriation of funds results under Adams in the sanction disciplinary council thinks should be applied in this case. Now, all that we're asking the board to do is to, given the state of the law, apply the law to these facts. We understand there's arguments on both sides, but we don't see on these facts a preponderance of the evidence to show that the respondent acted suffering from AUD was a substantial cause of the misconduct. The misconduct benefited his firm. The misconduct required conscious and thoughtful premeditation. The respondent admitted to months of time when he was not suffering from binge drinking. The evidence simply, and the burden is on respondent, not on disciplinary counsel to show, and he has not met that burden on these facts. By the way, in Ray Standback, we have a case which
I think we're way past time, Mr. Link. If you could take 30 seconds, I give that to Mr. Driscoll and sort of wrap up.
Thank you. We asked the board to look at the record in this case, and based on the record in this case, based on the state of the law in the District of Columbia, apply the law to these facts and make its own ultimate factual determination. And we believe if the board does so, it will have to conclude that, in fact, In re Adams should apply, Kersey mitigation does not apply.
Thank you very much. The case is submitted.
Thank you, everyone.
Thank you.